Hello everybody, it's Rick. It is January the 24th, 2020. My email is rick, RICK0327 @me.com. You can email me if you're interested in exchange for a gift to receive my paperwork. Paperwork is for child support, Title 4D child support, not child support with divorces per se, although I have knowledge with that. But I have a lot of paperwork. I have a lot. I'm not a lawyer. I'm not an attorney. This is not legal advice. Everything you see here, it's a good idea to double check it. Okay. Anyway, things are okay. I hope everything's all right with you. The new year is going pretty good so far. The last video I showed you guys a couple of people who had success. I have 3 people who have stories to tell, had success on their own. Okay, my friend here, Family Freedom. He filed a writ of prohibition in the appeals court, and they dismissed it, and it's on its way down to the lower court. Okay, so here's the thing: I have 2 cases, one with child support, another with child custody. That became a witch hunt against me. Anyway, I'm the petitioner of the case. I wanted to deal and give it a try one more time in this situation with your documents in this case, and I went directly to the Court of Appeal, where after 3 attempts in a week of denial with certiorari, habeas, and quo warranto, the document that ended and stopped all the abuse by this corrupt judge was your writ of prohibition document. That is the letter that I sent you last week. Yes, I don't want to post it because it's got personal stuff on it. They dismissed the case in the lower courts. Yesterday I confirmed them, and they sent the order to the lower court. So that's good. It's a good. You had a higher court. You had to go to a higher court. Here's the thing. The thing I'm looking at right now is we're communicating with the court before going. Okay, now if you're already in court, you're going to have to do what he did. You're going to have to go to a higher court. The court, they're never going to let you go. Okay, unless, you become a pain in their rear end. And you start, well, what I had to do is I had to go sue. So I went to the federal court and sued. And then I went back to court. And they realized, that I meant business, and they treated me completely different. And I got to see a judge, and I got my support order vacated and $40,000 in arrears vacated. Okay, that was in August of 2016. I'm telling the story. Those of you that heard the story, you heard it. Those that are new, I have to keep telling the story. Okay, I'm a victim like you guys. I'm not somebody here. I'm not a supposed expert because I've watched a lot of videos and I feel like I have a good understanding. I know because I've been there. I got videos. Go back to my earlier videos. You'll see me in court battling these people. Okay. I like to think of myself as the real deal because I actually had child support. I paid child support. It destroyed my life. Okay. I definitely suffer PTSD from it because I don't ever want to go near a court, and a lot of you will probably understand what I'm about to say next. But I'm still afraid of the mailman. Okay, I don't know about you guys. I used to be a scared SHIT of the mail carrier. Okay, because never bring good news from these people. I mean, they send letters everywhere trying to steal your money. And it's very difficult to get them to stop. After I got the judge to issue an order, okay, I've become such a pain in the butt to my pension system because I was suing them as well, that they got the letter from the court, and they called me. Like, they couldn't wait to get, like, what happened was, I know what happened. They were never going to let me win, because if they admit that they let me win, then they're admitting they were wrong. Okay? So when they called me, Mr. Wyman, no, we haven't. And that was said. So then the child support agency sent it again to my pension system after they received notice from the judge that they have to stop. That's the thing with them. These people are very, very vindictive. They're out of control. Okay, I had to go back to the court and get another order from the judge to tell them to stop. Okay, but again, when the pension system received another income withholding order, they ignored it this time. Okay, because I told them, I said, you should have never honored the first one, because it's not real. It's not an honor order from a court. It's nothing but a piece of paper from an agency. So here's another subscriber who had success with my paperwork. He got the what happened here was he got them to stop taking his income back in June of 2019. And what happened was they threatened to suspend his driver's license. And then out of nowhere, he gets a letter this week saying that he's in compliance. And he didn't give them well, he's in compliance because they stopped taking his income. You know, he got them to stop. So if they stop taking his income, that means he doesn't owe any money. So that's the reason why. But he didn't do anything. He was just like shocked that he got a letter out of nowhere. One time they're threatening to suspend his license, and next thing you know, he gets a license that he's in compliance. Hey, that's a good thing. Okay. Here is number 2. He watches all my videos, and never mind your critics, you're helping people, stick with it, and you'll reap the blessing. See, when people receive my paperwork, they're really pleased. A lot of people are pleased with what they get. Here's another one. Now, this one's a good story. This is from Brenda. And I've been dealing with her for a while. She's a very nice woman. She's fighting for her son. And she sees what they're doing to her son. She's worried about her son. I remember, receiving emails from her. And so she shoot me a good email. Hey, Rick, I wanted to shoot you a short email about what happened with my son regarding child support. He received your paperwork and submitted the affidavits for proof of service. Exemplified, copy, etc. We'll get back to that. Long story short, they never sent what was requested, but they did respond, which means they received the request. Recently, my son was with his wife, and they were pulled over for a back light or something. Anyway, he was arrested for a child support warrant. The next day, I went to court and showed them your paperwork that my son had requested copies of the original court order, and so forth. I said, this is his notarized request, and he's locked up, and I'm here to pick up the paperwork on his behalf. Well, they did not want to give me anything. I was ready, though, because my son and myself had already been reading and preparing to use your paperwork. See, when you read my paperwork, you get educated, because you just got to read it. I explained why what we're talking about, with the laws and the Constitution, and what they have improved. So you just read the paperwork, you understand what you're doing. Okay. I knew enough to insist that they give it to me now. I had on previous occasions been with my son when he requested his requested his court order, and they said, we'll call you when it's ready. What they did was they filed for an exemplified certificate. What an exemplified certificate is the judge has to sign the order, and I think 2 clerks, or at least one clerk. And by the way, that's what an order from the court is supposed to have. It's supposed to have a signature by the judge, and it's supposed to be signed and stamped by the clerk. Most of these child support orders are completely void. They're void on its face. They don't have a signature by a judge. So if you're before one of these judge surrogates, which is a fake judge, they have no authority to issue an order. So if you have one of those orders signed by support magistrate, a magistrate, a friend of the court, whatever, you should take that order and go to the court and demand that you gotta pay a small fee and tell them you want an exemplified certificate. Okay, and see what happens. What you should do is do it on paper, just real quickly. I so and so, I'm requesting an exemplified copy of an order of support signed by support magistrate, whatever, on such and such a date. Please, or call them, or just you rather do it on paper because you have it's a record. That's really why. It might take a little while because you want to exchange, so you want to send it by certified mail, and hopefully you get a response from them. That way you're showing that you're trying. If they cannot give you an exemplified certificate, that means there's no order. So that's what they were doing. Okay? So what happens that they were giving him the runaround. Another time he went back and they looked up his name and told them they had a warrant from his arrest, so they couldn't, which they were just making it up. So if he has a warrant, why can't they give him a copy of the exemplified certificate? It's bullshit. And they wouldn't give him what he requested because he needed to go before the judge. Well, my son walked out. So this particular time when they stopped him and had no choice, they told me and his wife that he would have to pay $46,000 to get out of jail without bail. By the way, they're not allowed to jail you or detain you for a debt. Okay? We're going to cover that in a little bit. Because what they're doing is when you're being detained for a debt, they're making you an indentured servant, slave. Okay? And you should start crying in court that you're not a debt slave. You're not the 13th Amendment abolished slavery. And I'm not volunteering to be an indentured servant. We'll get back to that. So anyway, they scheduled the hearing by audio. This is the kicker. The judge let him go without requiring him to pay anything for child support. I believe it's because they finally gave copies of his case and there was no original court order. That's what they were asking for. They were demanding to see the proof of service. They have to prove, they cannot have proof of, if they don't have proof of service, they don't have personal jurisdiction over you. Okay? That they have to personally serve you with a notice to appear, summons, or whatever. Okay? There was not a proof of service. Heck, they had two different addresses. One was where he was renting the place. The other was for my home address. Neither which he received anything. Okay, so how can they have a warrant? So in other words, he didn't show up. They put out a warrant for him. And then what they do is they arrest you and then they want the money. So, tried to make it, but just amazed the attitude toward with the paperwork. I think they know that he's on their tactics because of the paperwork. He had been locked up a couple of times, always had to pay something to get out, even lost his job behind them, locking him up. He's now working on the affidavits demanding to vacate default judgment for lack of due process and challenge jurisdiction. This is exciting for him because he was unfairly treated until he started asking for proof. I'm happy for him. And I know he has a long way to go, but if something happened because of your paperwork, thank you. And that's what, here's a mother that fought for her son. She wouldn't take no for an answer. Okay, it was a happy ending. They were asking for $46,000, he got out of jail. And he proved a couple of points now. Okay? So that was 3 people. Okay? The 13th Amendment. Neither slavery, now here's the kicker, watch this, nor involuntary servitude. Involuntary. So in other words, what they're implying is it's okay to be a voluntary servant. And that's what they're doing when you go to these child support proceedings. They're tricking you to appear, and then you're unknowingly consenting by, that's why I mentioned in the last video, you got to go in there and listen, again, I told you guys, I don't want to know. Okay? It's none of my business. Some of you go in there with the guilty mindset because maybe you aren't. All right? Get it out of your head. Okay? The bottom line is your business between you and your offspring is between. The government has no business interfering. They're just doing it because they're making money. They don't give a rat's ass about your children. Okay, they're just trying to make money. That's what this is all about. So, you got to go in there and say, I'm where's the evidence that I'm not supporting my offspring? Okay, you got to make a stink. All right, so that's what this is all about. So you got to say, I am not a slave. Are you making me a slave here? Am I free to leave here? Okay, they trick you into showing up there, and then you're giving them consent, and you're consenting to be an indentured servant. Okay, that's what you're becoming. And indentured servant. In the past, a worker who agreed to work for no salary. Well, I just had a guy email me, and the guy's not working, and they're telling him he has to work. This is so that you're a slave. Here's the thing. Somebody sent me Turner versus Rogers. It's 2011 Supreme Court case. There's a way on the internet you could actually listen to the. Actually, I think you go to Supreme Court Department of Justice. I think you can find the court cases. Turner versus Rogers. You could actually hear the judges, the case going down with the justices, and Justice Scalia said, well, wait a second. If he's not employed, how can he be in contempt of court? See, if you're not employed, you're not willfully not paying support. Okay? The whole thing comes down to willful non-support under their definition. Okay? Under their definition. So, how can you be in contempt if you're not working? You're unable. They're supposed to give you a hearing, okay, an indigent hearing, because if you're not working, you're indigent, and they never do that. They go straight to a warrant, and then somehow a civil case becomes a criminal contempt case. I mean, they just make things up as they go along. They just want their money. They want you to get in there, okay. So basically, what it is that you're a slave. When you're an indentured servant. What they used to have people. They used to come like working on the subways and stuff in New York City, and they were like basically they were like indentured servants because they were being brought here, and as part of the deal to come here, you had to work. Crazy. All right, so what do we got here? All right, so I'm gonna end the video shortly. I'm gonna have I'll make a part 2, but what I'm looking at is hold on a second. I'm looking into. I have one guy just the other day. He sent in one of the affidavits to the clerk, and they're supposed to respond within 5 days. They didn't respond. So what we're doing now is you're gonna take the affidavit that you sent certified mail. That's your evidence, and then you're going to go and file a default judgment in the court. As proof, what we're doing is we're not walking, we're going to do everything we can to stay out of that court because it's almost impossible to win. Okay? So what you want to do is you're switching things around on them. You're turning the onus on them. And I'm playing around with this other thought. You're free. You know, you're not a slave. Okay? You're a man. You're a woman. Okay? It's very important to establish when you're there that you're a living man or a woman with blood flowing through your body. I mentioned that in the last video. Because when you have blood flowing through your body, you're not an object. You're not a thing. You are not a person. Okay? 28 U.S.C. Section 3002, 10. Person includes natural person, including an individual, Indian, a corporation, a partnership, an unincorporated association, a trust, and a state. Do you see a man anywhere? Laws are made, codes and statutes are made for persons. They're not made for men and women. Okay? Remember, I mentioned in the last video, you do not let them call you an obligor or debtor, non-custodial parent. Those terms, they don't have any rights. They don't have unalienable rights. Okay? So we're going to communicate before we go to court. Okay? Do is we're going to send a notice to the clerk. Hopefully you got a little bit of time before appearing. And you want to demand evidence of personal jurisdiction, evidence. See, the way it's supposed to work is the plaintiff or petitioner, usually it's the plaintiff in a civil matter, is supposed to provide evidence of an injury in fact, okay, and which was caused by you, or they don't have standing. But what happens is they get you to show up, it never gets established, and then you cannot leave because they bombard you with all these non-final judgments because the case just keeps going on forever, okay, and these orders, they go on forever. Well, you don't want to go up. So if they do not provide evidence of an injury in fact, then you go and you file sorry guys, give me a second here. A notice of default. Okay, you file a notice of default. And you get it stamped. And then if you really want to get cute, when you get the notice of default stamped, then you take it and then you can make copies, and you can send copies to the district attorney, the attorney general, the state attorney general, you know, just to prove that, you know, that district attorney, did I say that? The district attorney as well is proof that you file a default judgment. That way, if they go and they issue a default judgment against you for not showing up, you can go to the court and show a default judgment to get it dismissed or to get it vacated, the default judgment. Or when you file the vacated default judgment, you have evidence that you communicated with the court. Now, another thing that I'm playing around with is thinking about, it's a contract. This is all contractual stuff. They're all contractual terms. They don't want you to know it. They won't admit it. Okay? Support obligation, you're a debtor. These are all contractual terms. That's the reason why they got to scare you to show up. So when you show up, you're implying consent. Well, first of all, most of the time you're a nervous wreck. You go there, you don't even think about saying, I'm not consenting to this. Wait a second, I only showed up here because you scared me. You told me I was going to get arrested. You told me I was going to get my license suspended. Those are all grounds for fraud. Okay? So So we're gonna, before we can communicate and send, tell them that you're not going to show up unless you pay me $1 million. What do you got to lose? It's a contractual issue. Okay? And in the next video, we're going to talk about filing a notice to the judge or whoever it is that you're going to accept their oath of office. Okay? A lot of times, you've probably seen videos on the internet of demanding to see a copy of the oath of office. They're never going to give that to you. Okay? They're never going to give it to you. So what you're going to do is you're going to say, well, I'm accepting your oath of office. And if you act outside your oath of office, you're vacating your office. So they're no longer a judge, or they're now acting in their private, as John Doe, Jane Doe judge, fake judge. Then you can hold them personally liable for damages, because a judge is presumed to have judicial immunity. But when they always, and the way they word it, they're always acting like the way they word it, like the judge is always right, right? But if you have proof that they violated your unalienable rights, you're first of all, before you demand $1 million, or when you notify them that you are accepting their oath, you're going to notify them that you're a man, you're a woman, you're not a person, you're not an inanimate object, you're not an incorporated corporation, a trust, whatever. Okay, you're a living man or woman. Okay, and that's what we're going to do. All right, so I'm going to end this video. You saw, I had 3 people successful with my paperwork. I'm not, what I'm saying here is I think it would help you to reach out if you have, to send a gift to get the paperwork. I'm telling you, I give you the best chance you're going to get. Okay, look, these are all the affidavits I provide, and this is just one folder. Okay, I probably provide over 75, and I'm telling you, that's the best opportunity you're going to have. Once you hire an attorney, you're giving the court jurisdiction. You're telling the court the Constitution doesn't matter. There are no lawyers that are going to stick up for your constitutional rights. They're representing the court. That's their duty to. Their duty is to the court first, and to their wallet second. You don't even matter. Okay? So what I'm saying here is, this is your best opportunity. Okay? So if you're interested, send a gift. You're going to receive by email, you're going to receive all of these, you're going to receive about 15 emails with attachments. Each one of they're going to have different titles on the subject of the email telling you. So right here it says court affidavits filed before appearing in court. Challenge personal jurisdiction, demand discovery of evidence, change of venue, dismissal. Here we are, right here. I'm talking about it. Demanding a trial by jury. See, when you demand a trial by jury, that is a right that a man and a woman has under their state constitution. So right off the bat, when you file that and they deny it, they're automatically, so right there, they're vacating their oath of office right there. That you're going to notice. Okay? So that alone, you're going to contest, you got an objection. Non-assumpsit, okay? We talked about the last video, the improper grammar. So, you got special appearance, notice to vacate, default judgment, you got vacate contempt, okay? This one here is if you got suckered into signing. You ever notice that why do they want you to sign? Because once you sign, that's your consent. When you do not object, you do not contest, you're giving them consent. Okay, I showed you earlier with Brenda. She didn't take no for an answer. So she didn't consent to their bullshit. Okay? All right, guys. I went on long enough. Oh, my God. 30 minutes. All right. So I'll talk to you guys very soon. Bye.